G'day, this is the third video and it adds to the other one, doesn't take away from it. This is the Constitution of the Commonwealth of Australia. It both establishes it and puts it in the position where the people are sovereign and supreme. The Parliament is subservient through the people as representatives of us, not representatives of their political party, which they would have you believe is the accepted way. It's not. Conscription was put in, preferential voting was put in and debunked yesterday using the Constitution. Now when you look at this Constitution, it says an act to constitute the Commonwealth of Australia, 9th of July 1900, when it was proclaimed into law in England as an act of the British Parliament. The majority of the text of it comes from a draft copy put together by people in Australia to represent our wishes, and it was granted through this Constitution. It says, whereas the people of New South Wales, Victoria, South Australia, Queensland and Tasmania, humbly relying on the blessing of Almighty God, have agreed to unite in one indissoluble federal Commonwealth under the Crown of the United Kingdom of Great Britain and Ireland, and under the Constitution hereby established. The Royal Styles and Titles Act enables the reigning monarch to change any part of this, which is the preamble to the Constitution. And people have said, they took out Ireland and made it Northern Ireland, so that nullifies it. No, it doesn't. There's nothing to do with that. And then it goes on, and whereas it is expedient to provide for the admission into the Commonwealth of other Australian colonies and possession of the Queen. Be it therefore enacted by the Queen's most excellent Majesty, and I won't go on to the whole lot, because when you go down to 3, you see where after Queen Victoria has declared that Western Australia will go in, she was satisfied that Western Australia wanted to go into Federation. She was satisfied, so she proclaimed it. And that is on the wall of the Church of England in St George's Terrace, Perth, now given a title of the Anglican Church, which of course is not true, in my opinion, based on the fact that it was the Church of England. Who changed it? Nobody in this country. Now, it shall be lawful for the Queen, with the advice of the Privy Council, to declare by proclamation that on and after a day therein appointed, not being later than 1 year after the passing of this Act, the people of New South Wales, Victoria, South Australia, Queensland, Tasmania, and also of, if Her Majesty is satisfied that the people of Western Australia have agreed thereto, of Western Australia, shall be united in a federal Commonwealth under the name of the Commonwealth of Australia, but the Queen may at any time after the proclamation appoint a Governor-General for the Commonwealth, which she did, with a letters patent. The Commonwealth shall be established and the Constitution of the Commonwealth shall take effect on and after the day of this. I won't go on with that one because you can read it for yourself. It's self-explanatory and it's available if you want it by contacting us. This Act and all laws made by the Parliament of the Commonwealth under the Constitution shall be binding on the courts, judges and people of every state and of every part of the Commonwealth, notwithstanding anything in the laws of any state. And the laws of the Commonwealth shall be enforced on all British ships, the Queen's ships of war excepted, whose first port of clearance and whose port of destination are in the Commonwealth. The reason being, the Queen's representative, being the Governor-General, is the Commander-in-Chief of all the military in this country, not that person that was put in the other day. Nothing to do with her. She can't be and isn't accepted under the Constitution. Now this section, contrary to what you're taught by and to me, establishes the Commonwealth. It says, in inverted commas, the Commonwealth shall mean the Commonwealth of Australia as established under this Act. not by Clause 9. The state shall mean such of the colonies of New South Wales, New Zealand, Queensland, Tasmania, Victoria, Western Australia and South Australia, including the Northern Territory of South Australia, because it was still joined to South Australia, as for the time being are parts of the Commonwealth, and such colonies or territories as may be admitted into or established by the Commonwealth as states, and each of such parts of the Commonwealth shall be called a state. Original states shall mean each state as are parts of the Commonwealth as its establishment. Now that's easy to understand. The Federal Council of Australia Act 1885 is hereby repealed, but so as not to affect any laws passed by the Federal Council of Australia, or Australasia, and enforced at the establishment of the Commonwealth. Any such law may be repealed as to any state by the Parliament of the Commonwealth, or as to any colony not being a state by the Parliament thereof. To repeal an area of a state, as in the Northern Territory, requires compliance with Section 123. It can't be changed. After passing this Act, the Colonial Boundaries Act 1895 shall not apply to any colony which becomes a state of the Commonwealth. The Commonwealth shall be taken to be a self-governing colony for the purposes of this Act. That's clear. Where do you get the idea we can become independent and sovereign without permission from the British Parliament, without the rescinding of the letters patent of the 29th of October 1990, which cemented all the letters patents, all the colonial laws, everything, including every part of this, into place, and it can't be changed without permission from the reigning monarch. Why? Obviously Queen Victoria didn't trust politicians, and with just cause. Look at the lies and fraud that come out of this country. Were they satisfied? No. As explained yesterday in that video, they tried to lie and set themselves up with the ability to conscript us into anything they wanted. They lied and tried to say we have to vote multiple times in clear contravention of the Constitution, Section 8 and Section 30. They didn't like the fact that Quick and Garron had overturned all their nonsense and lies by putting the truth and the interpretation by the people who framed it. Those interpretation goes right back until just after Federation, when the first copy of the annotated Constitution was put in place. The annotation carries and contains the interpretation by the framers. It was collated by Dr. John Quick and Sir Robert Garron. It wasn't written as a story, which is what the Green Book is, of the idiots who decided they had every right to change everything when they had none. Clause 9, which Anne Toomey says establishes the Commonwealth, it doesn't. The Constitution of the Commonwealth shall be as follows. The Constitution is divided in as follows. It's just the chapters it's divided into. The actual establishment comes under Clause 6. As I said, the Commonwealth shall mean the Commonwealth of Australia as established under this Act. And Toomey says, oh no, none of those clauses actually apply. And Toomey, you're wrong. Correct it or become a liar, because what you're saying is a lie. Now, 1967 was when this ridiculous mob of political party-based politicians separated Australia from its constitution. 1967. How? Simply, we had a referendum to recognise Aboriginal natives into the Constitution. Not natives, Aboriginal natives. They were already in under the state constitutions. It says all natives shall be fed, housed, clothes and given us small amounts of money. Right up until half castes. What are half castes? Half Aboriginal, half white. There's lots of them. They've extended it for the benefit of the political parties, but they had no power to do that because it would change. After the 1967 referendum, the Parliament dumped the Constitution. Prior to that, they allowed, in their words, but without lawful authority, Bob Hawke to issue a letters patent for the office of Governor-General. Treason and fraud. Dick Yardley covered it. The person I talked about yesterday took that book and got it produced and is now selling it to make money off what Dick Yardley researched and wrote. A clear case of theft, in my view. And what they did is under 23A, the provision of maternity allowances, widows' pensions, child endowment, unemployment, pharmaceutical, sickness and hospital, and all that, that was not in the original Constitution. There was no 23A. There was 23, which dealt with invalid, old age, and widows' pensions. It's in the Constitution, the proper one. So what they really did is they lied to you. You can't say it's any other way. They lied, which is what they do. Then they changed 20 or two X's, a V and a 1, just so people can understand that. People of any race other than the Aboriginal race in any state for whom it is deemed necessary to make special laws. Who's the Aboriginal race? Aboriginal natives. Were they originals? No. No, they weren't. Negritos were. This is not an argument against these people. They were here before white people, and they're entitled to their sacred sites and everything they established here first. But they gave them, they took out of the Constitution the people of any race for whom it is deemed necessary to make special laws. You can't make special laws for everybody on the face of this country. You weren't granted that. You were trying to grant yourself that. So that's 23A and 26 were changes to the Constitution, not alteration. 128 says method of alteration, not change. You changed it. This is a letters patent. The only person who can change it is a reigning monarch. Did you send all these modifications to the reigning monarch? You say, she signed it. I say, where's the evidence? Where is the proclamation from her, which would need to be that she rescinded those sections of the Constitution to be replaced with what she put in? There is none. Never was. She signed the top left-hand corner, Elyabeth. That does not spell Elizabeth in any language. It's Elyabeth. She signs up there to say she's read it. If she approved it, it would be down the bottom, given under my hand at Balmoral or wherever, this day, this date, by Elizabeth II. Not by anybody else, spelled Elizabeth, not Elyabeth. You cannot change that. Why did you? It's on several documents and it's not true. Now, where else did you change it? You go to 126. The Queen may authorise the Governor-General to appoint any person or any persons jointly or severally to be deputy or deputies. We'll just leave that because we don't need any more. All I intend letting you know is that's 126. What did you do with 127? You didn't forget at all. It says in here what you did when you committed blatant treason and removed this constitution. Did you remove it? Absolutely did. And no longer complied with the letters patent or the authority granted by the Commonwealth Constitution Act to exist. You lied. It says here, Section 127 repealed by number 55 in 1967. That's when you did it. You lied, cheated and stole the rights of every Australian. That's why Anne Toomey says the Red Book and Green Book are the same. The Red Book says, clearly, supreme, absolute and uncontrollable authority remains with the people, not with the Parliament. So it is the original text, because it says that in the original text. It says on page 346, not all enactments of the Parliament are valid, only those made pursuant to, in accordance with, and under the authority granted by the Constitution, and those laws only are binding on the courts, judges and people of every state. All other laws are void. Page 676 says the Constitution sits above both houses of Parliament. That's not what you're teaching, Anne Toomey. It's not what the Parliament's teaching, not what political parties want us to believe. It says down the bottom of the page, the Parliament is not supreme. The very essence of federation is that must be so. The Parliament, like everybody else, is subject to the law and must abide by it. That's clear. Page 791 in Quick and Garrett. It says clearly, neither the federal nor the state parliament are sovereign bodies. They are legislatures with limited authority. If they attempt to pass a law in excess of that authority, the law is a nullity and affords no obedience. So that makes this book, which is a book of lies by political parties, this is the evidence that proves every political party is sitting in blatant treason in this country. Every person working for them, person being living, breathing, man or woman, is guilty of the treason. Now it's revealed to them. Isn't it interesting? But at the end of 128, it requires the absolute majority of an absolute majority in Parliament to pass it first before it goes to the people, state by state. So the majority of people in a majority of states vote for something so it can become law. But you come unstuck because you didn't think people would vote for the native people of this country, the Aboriginal natives and the natives. Two separate people, Negritos and Aboriginal natives. Look up the word, you understand what I'm talking about. I'm not going to go through everything all the time. Don't worry, I have a lot of friends that are Aboriginal natives. They're really good people. You got the occasional rat bag, but there's plenty of white ones 10 times worse. What I'm telling you, by the removal of 127, you negated the Constitution. And you did it deliberate. It wasn't an accident. And then Anne Toomey says, oh, look at that. The Parliament didn't have to have a referendum for the Australia Act. No, because Australia didn't exist. Couldn't exist after 1967 when you removed it. You realise what you've done. Don't say you didn't. Because you produced the Green Constitution, and with all the opinions, and look at that, you put 127 back in. Where did the authority come from to call a referendum after 1967? Where did your authority come from to pass any laws, rules, regulations, or anything else? You didn't have it. You took out the only authority you had. Read the preamble, read the 9 clauses, and read the Constitution itself. You took out all your authority. You could not pass any of those actual laws because there was no authority left. You can't say there is, because this little book, the Constitution, as altered to the 31st of October 1986, says so on the front. Who put it out? You morons. And I'm calling you morons because you're so stupid to produce the garbage you produced. You're so stupid. Why did you do it? Because you have no idea. Hon, can you come here, please? Where's the Constitution Act? It was here a minute ago. This is the state ones. Ah, it's here. Sorry, a little confusion there. Right, this sits until we take it out. We voted in 1999 to take it, to leave it there completely, and its interpretation completely. Unfortunately, even though some of the decisions of the High Court after 1967 were nonetheless brilliant, absolutely brilliant, by people who knew what they were talking about, until you corrupted the High Court. When did you corrupt the High Court? That's why Western Australian courts, including the one in Geraldton last Wednesday, the 15th, refused to acknowledge that this is the original and only constitution for the state of Western Australia. This is the one that they put in. How did they put it in? Through lies, fraud, treason, and theft of everything belongs to the people. This piece of rubbish, which is all it is, removes a lot of things. How do I know that? Because it actually says so. And when you read this, you find out everything that's in it. It's removed. And what was repealed. And when you look at it, you can't believe the lies and fraud that use, this is the letters patent, by the way, you use the 1899 Western Australian Act. All the Constitution of Western Australia continues subject to the Commonwealth Constitution. 106 says so. There were no states before Federation. When I went to the court in Glue versus the Greenwich Shire, the Wheeler, Pullman bus, the three quorums, not judges, they were quorums. Quorum is an unelected judge, a person impersonating a judge who isn't one. So they weren't one. And what they purported to rule is the states existed before Federation. So did their constitutions. Get rid of that fly. Get out your little rat bag. What happened? When they took this out of place, they forgot when it came to 1979, because this, under the provisions of Clause 7, ceased to exist at Federation, actually on the 9th of July. Yeah, I know, I've got to keep getting a stupid fly off the screen. It's all right, my wife is correcting me in my sitting position. Not a problem. What they actually did is added local government to this one, which did not lawfully and does not lawfully exist. The stupid lawyer tried to tell me last Wednesday in the waiting room at the court that what I'm saying is an opinion. This is not an opinion. This is evidence of blatant treason and fraud committed by the Western Australian Parliament at Federation. It is the evidence of it, like the Blue Book. It is the evidence of blatant treason and fraud. Because when you go into this one, 52 is not local government, 53 is not local government, because this is the proper one. You couldn't add it to this because you didn't recognise it. You wanted to continue recognising this and stating that the Parliament had the right to produce that Act. Clause 7 says you didn't. Didn't have it. But add to that the fact that in August 1902, New South Wales removed its constitution and replaced it with another one. 1922, Queensland removed its upper house. Isn't it interesting? 1934, South Australia and Tasmania removed their constitution, replaced it with another one. 1975, Victoria removed its. There's never been a lawful parliament until Western Australia could put this in. You needed 6 states. What I'm explaining, you need to perceive what I'm saying, and you'll see we don't have a lawful federal parliament, and we never have. Even if they had the right under external affairs powers, which they did not. They did not. They can't show where in the Constitution they get those powers to sign all agreements with other countries without going to us. But if you think with a brain, you will know, how could you sign those agreements and then come back and tell us that we're going to do it when we're sovereign and supreme in the Constitution? Supreme, absolute and uncontrollable authority remains with us. Robert French said in a statement and a big lecture around 70-odd pages, I read it a few weeks ago, and Anne Toomey had an input into that there's no way you can sign up any of those agreements, implement them here without going to the people. You think you could just sit there and lie, mislead and deceive these people, committing blatant treason. Blatant treason. And get away with it. You almost did. You see, in 1979, there was, up until 1979, there was no local government in the state constitution. There was no local government in the federal constitution. That's why the 1988 referendum, you say it failed, it didn't exist. You had no power left since 1967 to present it. Am I correct? Yes. Because the state constitution, this one, not the fraudulent one, but even if you say the fraudulent one, so I'll put the two together for the time being to make my point. If they existed, how did you add it to them when it wasn't in the federal constitution? 106 of the constitution is clear. This is why Anne Toomey changed so much stuff for the benefit of the political parties. Whether she was taught that and decided to teach it without referring it to the Constitution beckons belief. Why would you continue saying something you know fully does not exist? Don't be silly. You know you are going to pay a penalty for what you're putting out there if you don't correct it, so I suggest you do. It's in here. So how does this continue subject to the Commonwealth Constitution when there is not another tier of government in the Commonwealth Constitution? Wake up. There is not another tier, so it doesn't exist. No, Justice Kirby said, no parliament by preambular assertion can speak an authority into being when none exists in law. Do you comprehend what that means? You had no authority. You had to comply for this, if it was lawful, to go into the Commonwealth Constitution. You had to comply with the provisions of the Constitution. No local government, which you've given powers way beyond the parliaments of the state, according to you, but you couldn't because you don't exist. And you're now saying that this is the true one. No, it's not. It ceased to exist under Clause 7. Read section 51, subsection 38 in the annotated one and it'll explain it. There was only 7 legislative areas exercisable by the Australasian Council and even less by the colonies, and all 7 are contained in section 51. There's nowhere in 51 of the Constitution gives the states authority over land. None. Because they didn't have it. And to me, after a prompting from several people, I was one of them, but I'm not taking credit for opening a brain up a little bit. Page 935 states the states have authority to set up municipal authorities, which they were from Federation up until 1979. They were municipal authorities, councils, roads boards and such like. looking after roads, footpaths and everything else, with no authority over land. No authority, unless it appeared in the federal constitution as a granted right, which is what the 934, 35, 36 is all about in the annotated one. And then Toomey referred to it to say, oh, local government was before federation, it was then. Yes, if you've got a bent mind and you want to mislead and deceive people, which is exactly what you did. You said local government existed before federation. Yes, it was the parliaments of the colonies, which are the local government of the British Parliament here, in their colonies. It can't be taken any other way. It is a fact. It's not interpreted in the wrong way. It's not an opinion. It's a fact. They were independent governments set up as each state was colonised, or each area called a state, which became a state under the Constitution, 107, 108 and 109. No other way. Now, when you look at 1979, you added local government in every state to the unlawful state constitutions, because by 1975 there were no lawful ones. None. And when you look at the unlawful one of Western Australia, you mistakenly or without any ability to perceive what was going on, added it in place of repealed sections of a constitution which was literally made letters patent on the 29th of October 1890. Is it true? Go look it up, you'll find out. This is the Constitution of Western Australia. This tells you how you will vote. Coupled to this was the Imperial Act, also a letters patent, as how voting will take place. If you say, oh, the Parliament had the right to, the Federal Parliament had the right to change it, according to you, yes, but there was no Federal Parliament and there never has been. It needed 6 states, 6 state constitutions to be in place to set up the 6 parliaments of the states and all the courts therein. Read your constitution, it's clear. How do I get that? Read section 128. Majority of people in a majority of states vote before an amendment, an alteration. Method of alteration, it says, not change. Wake up to that. Now, there's another thing that you would like to put over the people